Hello, I'm attorney Dan Marr from the Nashua law firm of Hamblett Kerrigan here in New Hampshire, and I've been practicing for approximately 36 years in New Hampshire and about 28 years in the Commonwealth of Massachusetts. And during that period of time, I've dealt with a lot of cases dealing with questions of whether or not the elderly have been financially abused. And I'm going to be talking today about the question of, can a caretaker in New Hampshire take the assets of the person they're taking care of upon death? And there's a lot to that to unpack in that for this program. So first off, the question comes down to is the person that they're taking care of mentally competent to begin with? Are they able to make decisions for themselves? If they're not able to make decisions for themselves, then they can't do anything from right down to going down to the bank and putting the caretaker's name on the account. They're not allowed to do that, so it's a void to begin with. Then the question comes down to, if they did put the person's name on the account, was that for purposes of just to take care of them, or was it actually for purposes of giving it to them upon death? In New Hampshire, the state statute dealing with bank accounts, if you put somebody's name on the account, the bank can release it all to that person upon death, or either person on the account can take it. So if it's or if it says that person or the other person, then either one can take the money out. Joint bank accounts are basically that situation. So those simple bank accounts sometimes don't work for you. You want to make sure you understand if you're actually, if your parent wants to provide a caretaker access to paid bills, you want to make sure the account is set up that way rather than just adding the name to the account. So that's one thing. The bank would be protected if they, under that situation upon death, if the monies were taken out by the caretaker, but there still could be a challenge by relatives saying that wasn't the intent, and you could still go to court and the judge might decide, hey, caretaker, you really knew that this was not, or this was not set up for you to take all the money of the person you were taking care of. There's something called undue influence. Undue influence is a situation where somebody who is mentally competent can still have their free will usurped by things like, there's only one person that's taking care of this person. They feel obligated to this person. If they don't make this person do what, or don't give this person what they want, they're going to go in a nursing home. And they really don't want to go to a nursing home. I'm giving an example. Some people do want to go into assisted living, but say somebody doesn't want to go into it. They want to stay home, and this caretaker's keeping them home. And there's a lot of power there in that caretaker by asking them, saying, I'm giving up a lot of my life. I want you to pay for me. Can that be a level of undue influence? At some point it might be. And it really is a situation of, are you usurping the person's free will? I've litigated these cases, and it really comes down to a lot of facts and circumstances as to whether or not this person really thought that they had control over their destiny, or did the caretaker in their mind. In this situation, though, when the caretaker is taking care of the person, it is for the caretaker to prove they have the burden of showing that there wasn't undue influence in that situation. So in the situation where you have a fiduciary role with the other person, you have the obligation yourself to show on your burden of proof that there was not undue influence. But you can deal with that. I've had over a week-long trial in regards to one of these cases, and I was representing actually the caretaker in that situation, and the decedent had actually came to us first and said, I want you to protect them, and the caretaker, and we did, from the daughter, who later did bring a lawsuit after dad died. So sometimes families aren't the best situation, but in that situation the caretaker was the one who was taking care of the person, and that's what the decedent wanted. There's no such thing as a family inheritance. If you've heard that before, I've argued that right up to the Supreme Court, New Hampshire Supreme Court. There's not an argument of a family inheritance. You might have a estate plan where one spouse may contractually agree with the other that they're going to distribute their assets a certain way. That could be binding, but the notion by the children that they have a family inheritance, there is no such thing. It is the parents' choice. Often the parents do choose to leave to the children, but sometimes in this situation, the caretaker can take care of it, can be taken care of. So that's an issue that happens in these circumstances. Again, if the person is mentally incompetent, you don't have this discussion. But if they're mentally compromised, if they're less than they were in their 40s and 50s and 60s. They're in their 80s now, and they're diminished capacity. They can be more subjected to undue influence, and again, undue influence of feeling that the person really doesn't have a choice in the matter but to leave this money to the person. Or they might be actually confused, and if there's a situation where they're confused and they don't understand that by signing, by way of example, putting somebody's name on an account, that they were actually going to leave that account to that person upon death, that would be a clear circumstance upon undue influence and also a mistake, and the courts can remedy that. Again, the bank's protected under the joint bank account statute, but that doesn't mean that you can't still go after the caretaker in regards to that situation. In my situation that I dealt with a trial, I've dealt with a variety of these cases, but the one that I had a long trial on, the person that did die, he handled everything himself on the computer. He was a whiz. He was in his 80s, but he did everything. He did all his online banking. He did all this stuff, and it was very clear that the caretaker didn't know that stuff. She wanted to be taken care of. In these second relationships, sometimes people think about, your first relationships with love and commitment, your marriage vows. In the second relationships, after somebody dies or they get a divorce, one person might be thinking, the slanted version of calling somebody a sugar daddy. They want the person to take care of them, and that person that is supposedly the sugar daddy wants a nurse. So you have the crass comments of sugar daddy and nurse. It happens. So you have a female, younger caretaker taking care of a male person that wants to stay out of assisted living facility. So he wants somebody to take care of him, and she wants somebody to financially take care of him. So they both are in a relationship that's mutually beneficial. That's allowed, and you wouldn't be able to prove undue influence. I've dealt with this quite a bit. I'm Dan Marr at 603-883-5501. Check out our website, nationallaw.com. And again, I've litigated these cases both in New Hampshire and Massachusetts. And I'm happy to help and happy to talk to you about the situation, whichever circumstance you're in. I've been on both sides of these cases. So again, Dan Marr, 603-883-5501. And check out our website, nationallaw, all one word, .com. Thank you.